Hi, this is Blaine Cluten for Cluten Law. So, what happens to my child if I die without a will? And this question breaks down into two different parts: the financial aspect and then the custody aspect. As far as the financial aspect, this is not that different from the question that we answered about what happens if I die and I have a spouse, and the line of inquiry that happens around intestate succession and who your heirs are. So as far as what's going to happen, I'm going to link back to that video in the description, because those two, intestate succession and the assignment as to the heirs, and then it's going to depend whether or not your estate is subject to requiring it to go through a probate or not, depending on what type of property you have. That's going to make a difference about whether or not the property is going to get probated in the first place. Now, the difference is with minor children, there are specific rules around passing through a will to a minor. And there's a Transfer to Minors Act, and oftentimes what ends up needing to happen is a guardianship conservatorship is set up, and sometimes what we do within the trust and not within the trust, but within the will document, is we create a testamentary trust within the will to provide for minor children, so that in the event of your passing and your children are still minors, that there would be a trust created within the will to care for those minor children. Now, the second part to this is what's going to happen from a custody standpoint if you're the only parent and you die, and what's going to happen to the children. Now, the first thing, practically speaking, that's going to happen is that a party like DHS is going to come in and take temporary custody over the children, unless there's some sort of family member that's nearby and can take custody over the children pretty quickly, which DHS is going to try and establish. The next part of this is that usually an interested party is going to have to file for guardianship over those minor children. Now, within my will prep documents, I will oftentimes designate a preferred guardian for minor children, and this gives the court some sort of direction about parents' wishes. This is not going to be binding on the court. The court is ultimately going to make that determination about guardianship, but this can at least be guiding. And it does also demonstrate what you want, what your intent is to other family members, so that they know who should be the party that's, whether it's family or close friends or family friends or whatever it is, that they know that they're the ones that should be going and filing this guardianship paperwork for these minor children. There is no automatic method that we could create a will or any other document that would automatically give effect upon your passing to one adult to a minor child. It's still ultimately going to have to go through the court. There is, however, a mechanism where you can give temporary guardianship over another adult person, and I'm going to link to that description also within the description box. But that's usually for something that's completely different from what we're talking about here today. But I'm going to give that so that you have a link back and you understand what we're talking about here. If you have further questions about what's going to happen to your children and providing for your children, and whether it's in the context of custody or whether it's in the financial context, please either talk to a financial advisor or an attorney or an accountant. These are the types of situations where it's very important to start planning for the unexpected and then the inevitable. This is Blaine Cluten for Cluten Law. Thank you.